Jai Hind to all of you. I am Updesh Kumar Jaiswal, working as an assistant professor in Department of Computer Science and Engineering, Ajay Kumar Garg Engineering College, Ghaziabad. Today, I am going to deliver a lecture of the subject Constitution of India, Law and Engineering, subject code is KNC 501, and the topic that I will discuss today is sources of law and contract law in India. Sources of law and the court structure in India. Firstly, I will discuss about this. A man is by nature is a social being. He comes into contact with other individuals in different capacities. These contacts or association are the mandatory consequences of modern civilization. In all these associations, he is expected to observe a code of conduct or a set of rules. The objective of this set of rules is to make human association possible, ensure that members of the society may live, work together in orderly and peaceful manner. These are the three major objectives for defining the set of rules. Definition of law according to Article 13(3) of Constitution of India. Clause 3 of Article 13 of the Constitution of India define law as under A. Law includes any ordinance, order, bylaw, rule, regulation, notification, custom or usage having the force of law. An amendment to an existing law is also known as the law. Law in the context of the provision of Constitution of India may also be defined as it is an act passed by the legislature and assented to by the President of India or Governor of a state. Article 111 and 200 of the Constitution of India. So, this was the definition according to the Constitution of India. Now, functions and purpose of law. To provide the justice, impartiality, nispakshata, continuity and uniformity. These are the major function and purpose of law in India. Now, what are different classification of law in India? The main classification is public law and then private law. Public law, it is that law which determines and regulates the organization and functioning of the state. It also determines relation of the state with its subject. The following law form part of the public law: constitutional law, administrative law, criminal law. Constitutional law, it is the basic and fundamental law of land which determines the nature of the state and the structure of the government. It may written as in India, USA and most of the other country, and unwritten as in England. Administrative law, it is the law which deals the structure, function and power of the organs of the government. The third subcategory of public law is the criminal law. It deals with various offences and has for its object their prevention by providing for and prescribing certain punishment for them. The another major category is the private law. It is the law which regulates relation of the citizens with one another, which are the public importance. In this sense, the state through its judicial organ educates the matter in dispute between them. Private law has the following fields: personal law, law of property, law of obligation. In case of personal law, it is a special law applicable to a class of people in India. Law of property, it is law related to transfer of property or immovable of the property. Law of obligation, it is law relating to contract, quasi-contract and torts. Now, another important topic is source of law. Source means origin, which something is ultimately derived and often refers to the causes operating before the thing itself comes into the picture. Legal experts differ differ widely to the view of the origin of law. One of the legal observer traces its origin in general awareness of the people at any point of time. Now, sources of law in India. It is also divided in two categories: principal sources of Indian law and secondary sources of Indian law. In case of principal sources of Indian law, there are four subcategories, and first is the customs law, that is also called as the customary. In Hindi, it is called as the prathagat. Judicial precedents, misal in Hindi. Statute law or legislation, and personal law. In case of secondary sources of law in India, justice, equity, or good conscience, and another one is the English law. Sources of Indian law. The main source of the Indian law may be summarized as follow: principal sources of Indian law, and first subcategory is the custom or customary law. Custom is the most ancient of all the sources of law and has held the most important place in past through its importance is now diminishing with the growth of legislation and precedent. Custom is a habitual course of conduct observed uniformly and voluntarily by the people concerned. No custom shall have the force of law if it in manner violates the fundamental rights. Requisites of a valid custom. In order to be valid and have a binding force as law, a custom may have the following requisites: antiquity, reasonableness, continuous observance, conformity with statutory law and public policy, consistency, obligatory force, peaceable enjoyment. Next subcategory, judicial precedent. This doctrine means adherence to the earlier decision and not unsetting things which are already decided. This doctrine is based on expediency and public policy. Why precedents are recognized? The practice of following precedents is necessary to ensure the certainty of any predictability of decision. This creates confidence in the mind of the litigants and the administration of justice become fair. Doctrine and precedents. Statute law or legislation. It is a law that is created by legislation, parliament or state assembly. Legislation is that source of law which consists in the declaration or transmission of legal rules by any authority duly empowered by the Constitution in that behalf. It is sometimes called just scriptum or written law. Some prefer to call it as a enacted law. In modern times, legislation is the most important source of law in all countries and all over the world. Personal law, source of Hindu law and source of Mohammedan law. These are the personal law. The source of Hindu law are four Vedas: Rigu Veda, Yajur Veda, Sam Veda, and Athar Veda. And in case of source of Muhammadan law, Quran, Ijma, Hadith, these were used. Secondary sources of Indian law: justice, equity, and good conscience. In the absence of any rule of specific law, usage or custom or personal law on a particular point arising before the courts apply the doctrine of justice, equity, and good conscience, which means in substance and in circumstances the rule of English law is applicable to Indian society and circumstances. So next is English law, common law, equity, and statutory law. Common law of England: equity synonymous with justice, and this one refers to Act of Parliament. In the absence of any rule of specific law, usage or custom or personal law on a particular point arising before the court apply the doctrine of justice, equity, and good conscience. I already told about this. Now, English law, which I already told, it has three subcategories: common law, equity, and statutory law. In case of common law of England, the chief source of the English law is common law as supplemented by equity and statutory law. The expression common law of England conveys those unrelated legal doctrines embodying English custom and English traditions which have been developed over centuries by the English court. Equity: the term equity has its origin in the Latin word that means fair or justice according to natural law, or right, simply natural justice. Doctrine of natural justice, equitable set off. And I already told, it refers to Act of Parliament. Structure of courts in India. As per the judiciary system, there are three levels of court in India as given below. The highest level is the Supreme Court, then lower High Court, then District Court. Supreme Court: this is at the top of all state and district courts, presided by the Chief Justice of India, because it is the highest authority of justice in India for the country India. The decisions made by the Supreme Court stands above all other courts. The Supreme Court of India is located in Mandi House, New Delhi. It was about the Supreme Court. High Courts: each state like Uttar Pradesh, Haryana, Bihar has its own High Court. In Uttar Pradesh, our High Court is in Allahabad, Prayagraj. In case of Bihar, it is placed in Patna. Each state has its own High Court, which is most certainly the highest judicial authority of the state. District Court: this is where most decisions go to for any dispute in their city or the region. Suppose if I am living Ghaziabad district, then I will go firstly for justice in the District Court of Ghaziabad. If any offence occurred here, each state comprises many districts and has its own district or subordinate courts, and the entire district is presided over by the district judge. Due to the integrated judicial system of the country, we can find a strong connection between all the courts. This means that the decision of the higher courts are binding on the lower courts. The appellate system in Hindi appeal sambandhi, punarvichar sambandhi, creates such connection. Due to appellate system, if anyone is not satisfied by the judgment of a lower court then he can proceed for the higher court for a fair decision. Branches of the legal system. In Indian legal system has two main sections, civil law and criminal law. Criminal law take care of misconduct of citizens which are defined as an offense or criminal by the law. A criminal case starts with filing a report with the local police, who then start an investigation of the matter. The court finally decide on the matter. In case of civil law, in contrast, it take care of dispute in the event of violation of a citizen's fundamental rights. The involved parties then file a petition to the relevant court. Finally, the court provides a solution, a decision thereafter to the dispute presented. Now, these different laws are applicable all over the India. While establishing a company, while doing a work in a prescribed manner, contract law is very important in India. So what is contract law? We should understand. Firstly, related to this topic, related to this concern, we should know what is contract. A contract is an acceptable proposal, agreement that is fully understood by the law and is legally defined or enforceable by the law. Or we can say an agreement enforceable by law is called as a contract. A contract can be described as a legally binding oral or written agreement which exchanges any combination of goods, services, money, and property. A contract is unique in that unless certain exceptions apply, parties are free to agree to whatever term they choose. This is known as the freedom of contract. The Indian Contract Act 1872 defines the term contract under its section 2H as an agreement enforceable by law is known as the contract. Contract law aims to provide an effective legal framework for contracting parties to resolve their dispute and regulate their contractual obligation. The law of contract is mostly self-regulatory, with the majority of contracts requiring no intervention. The courts make no consideration for whether the contract was fair or not. If it was agreed, it should be enforced. Despite this, on some occasions, the courts are willing to depart from the principle of contractual freedom. This is often where there has been an abuse of bargaining power by one contracting power. The Indian Contract Act came into effect on 1st September 1872 and is one of the oldest mercantile law of the country. This law provides guidance that help in the formation and compliance of contracts in regulated and organized manner. The Indian Contract Act consists of the following two parts: general principle of law of contract, special kinds of contract. There are two categories. General principle of the law of contract are contained in section 1 to 75 of the Indian Contract Act. These principles apply to all kinds of contract irrespective of their nature. The second category is special kind of contracts. Special contracts are contained in section 122 to 233, 38, 124 to 238 of the Indian Contract Act. These special contracts are indemnity, guarantee, bailment, pledge and agency. In Hindi, it will be applicable for क्षति, अगर कोई क्षतिपूर्ति हो जाती है, गारंटी देने के लिए जमानत या गिरवी एजेंसी तथा साझेदारी से संबंधित है। नाउ एग्रीमेंट इन सेक्शन 2E the act defines the term agreement as every promise and every set of promise forming the consideration for each other. An agreement is a promise or commitment given by one party to another party. It includes an offer that is made by one person and accepted by the other person. In simple words, an agreement happens when offer is made by one person and accepted by the another person. It consists of two or more parties. Essential of formatting an agreement: two parties are required. One offer or proposal should be there, accepted by the another person. There should be some promise and consideration are also taken. So, offer with acceptance, it becomes the agreement. The agreement or accepted promise, if it is enforceable by law, then it becomes the contract. All agreements are contracts if they are made by free consent of the parties competent to contract for a lawful consideration and with a lawful object, and no hereby expressly declared to be void. Section 10. Offer plus acceptance. These give promise. Promise and considerations are combined, then it gives the result as an agreement. If agreement is enforceable by any law, then it becomes the contract. All contracts are agreement, but all agreements are not contracts. It is very important to understand. All contracts are agreement, but it is not necessary that all agreement will be contract. If any agreement is enforceable by law, then it becomes the contract. It is represented by this diagram. Now, difference between contract and agreement. I have taken some basic sub-criteria to differentiate between the contract and agreement. Contract is covered under the section 2H. Agreement is covered under the section 2E. Definition. How these terms are defined. A contract is an agreement enforceable by law. Every promise or every set of promise forming consideration for each other is an agreement. Enforceability, third criteria, third basis. Every contract is enforceable. In case of agreement, every promise is not enforceable. Interrelationship, a contract includes an agreement. An agreement does not include a contract. Scope. Another criteria, another basis. The scope of a contract is limited as it includes only commercial agreements. Its scope is relatively wider as it includes both social agreement and commercial agreement. Other attribute is the validity. Only legal agreements are called contracts. In case of agreement, an agreement may be both legal and illegal. Legal obligation. Every contract contains a legal obligation, but in case of agreement, it is not necessary for every agreement to have legal obligation. So these are the major difference between the contract and agreement. These are the different resources which I have used to make this lecture. Thank you and Jai Hind.